This issue now transcends the various subjects of injustice that third parties, independent candidates, usually take on. Unlike any other Western democracy, no other country comes close to providing voters with such small number of choices and to making third-party independent candidates hurdle an almost insuperable series of obstacles just to get on the ballot. Norway has 7 or 8 parties. Chile has 9 parties. Germany has numerous parties. Canada has 5 viable parties. They have debates. It's very easy to get on the ballot in those countries. They're not afraid of new voices and choices. But in this country, if you run for federal office, whether it's the presidency, the vice presidency, or Congress, you have to adhere to a variety of laws that are interpreted by partisan judges, that can be invoked by well-heeled opponents, and if you run for president or vice president, you have to deal with 50 different state laws that range from modest hurdles to get over, as in New Jersey, to draconian numbers of signatures. North Carolina comes in with over 100,000, for example. You have to usually get twice the number of the statutory required number of signatures. That's only the beginning, however. Sometimes there are county differences. Very often there are differences as to who can walk the streets with a clipboard. In Arizona, for example, you have to be a resident of Arizona. You cannot call on Texas friends to come over the border and get signatures for a presidential candidate. In other states, there are restrictions as to whether anyone can sign your petition on the streets if they had voted in a primary. In Texas, anyone who votes in a Texas primary is prohibited from providing a verified signature for another candidate with a clipboard. So if that person does sign, it is disqualified by any opponent that wants to challenge it. Now, Pennsylvania is now the King Kong of ballot access busters among the 50 states. There's nobody now that can challenge the King Kong title of Pennsylvania, the state that has a city called the City of Brotherly Love. Philadelphia is now the center of a judicially implemented strategy that can just about knock off any third-party independent candidate if one of the two parties really wants to go all out to do so. Imagine receiving a call in Washington and being told that we had to have attorneys in 13 different courtrooms at the same time Monday morning in the state of Pennsylvania to go over the various signatures with the objectors and the judges. And this is, to call this archaic, I'm reminded of what Benjamin Franklin would have thought rather of something like this. If it wasn't so tragic, it would be high-level comedy. That we're dealing here with political bigotry of the first order. It's now generally recognized that it's bad form and unconstitutional to deny voters their right to vote on the basis of their race or their income or their gender or their religion. But for some reason, we have not reached that level of judicial tolerance and affirmation when it comes to candidates' rights to get on the ballot. Now, without voter rights, candidates' rights aren't worth much. And without candidates' rights, voter rights are not worth much. They both nourish each other in a more robust, diverse, multiple-choice democratic process. And when the Soviet Union was in operation, we would be told by the Soviets that 98% of the people in the Soviet Union voted in an election. And everybody in the U.S. would laugh. Not because they doubted the 98%, but because they knew there was only one candidate on the ballot. And in more and more districts in our country, local, state, and national, there's only one effective candidate. Either there's no candidate at all on the ballot to oppose the incumbent, or it's a nominal candidate by the opposing party, sure to lose, just as a matter of presence. There are 40% of state legislators in our country run without anybody opposing them on the ballot. In some states, like Massachusetts, it's 60%. So we start out with a one-party dominated political system that's getting worse with gerrymandering and with the ability of one party or another to basically marginalize the other party from the get-go. And then when you try to break this up a bit with a little more diversity, you see where the ballot access barriers kick in. Now, I wrote my first article on ballot access barriers against third-party candidates in 1959. So I'm not a newcomer to this issue. And in going back and rereading it, it is an understatement of what is occurring today. In other words, it's gotten worse. Here in Pennsylvania, to further complicate the political bigotry and to further the parochial and bigoted objectives of the Democratic Party, the judges in Philadelphia clearly misinterpreted Pennsylvania law in the following areas. They disqualified thousands of our signatures on the grounds that the voters who signed our petitions were not registered at the time. As Justice Saylor pointed out, there is no requirement in Pennsylvania law that voters 18 years and older who are eligible to vote are required to be registered before they can sign a candidate's petition to get on the ballot. The second area that was misread by the judges was that the address given by the voter signing the petition was different than the address that the voter gave when he or she registered days, months, years earlier. There is no requirement in Pennsylvania law that that address on the street has to be the same as the address that the voter filed when he or she registered. People move. And apparently if they move, they get disqualified in Pennsylvania from signing a petition. There were 3,200 signatures that were dismissed for no reason whatsoever. So this is clearly a corrupt system. This is clearly an unconstitutional system, regardless of what the majority of the Supreme Court of Pennsylvania decided, because they didn't do their homework, because they don't like these kinds of candidate access cases, because they think this is a two-party country, as does Justice Scalia. Whatever their motivations, a first-year law student wouldn't have made the legal error that Judge Collins made, affirmed by a majority opinion on the first round by the Supreme Court of Pennsylvania, without even an opinion, and affirmed on the second round with an opinion that was torn to bits by Justice Saylor, who actually does believe in reading the law. He does believe in free and equitable treatment of candidates running for office, who does believe that the voters of Pennsylvania deserve more voices and choices, and the access to the ballot should not impede that objective, and who does believe that throwing people off the ballot in such spurious manner is basically denying voters their right to vote for candidates of their choice. So what do we do about this? Well, the first thing we have to do is generate a level of public indignation that is lacking now. It's lacking because the two parties don't mind the system. It's lacking because there is a lot of misunderstanding of the system. And it's lacking because of the fraudulent and deceitful language against the Nader Camejo campaign by Judge Collins, paraded all over the state again and again and again through the media. Judge Collins, if he's capable of it, should be ashamed of himself. Even though he is elected as a Democrat, even though he's part of the Democratic machine, even though he has associates very, very heavily embedded in the Democratic Party from many years back, we still expect of Judge Collins an elementary level of recognition of what the plain wording of the Pennsylvania statute is, and judge that accordingly. He received a severe tutorial from Justice Saylor, but it didn't seem to affect him at all on the first round. He was confronted by Reed Smith, which is one of the 15 largest law firms in the world, representing, among others, an assortment of giant pharmaceutical companies, John Kerry, Teresa Kerry, and the Heinz family in Pennsylvania, with offices in Pittsburgh and Philadelphia, as well as offices on 3 continents. Reed Smith was retained by the Democratic National Committee to do, quote, political and legal work in 2004. I guess they were so excited by this work that somehow they thought they would engage in what they called a pro bono effort to get the Nader Camejo candidacy off the ballot in Pennsylvania. This is rather remarkably touching for the firm to distract itself from defending high drug prices, from defending unsafe drugs on part of its corporate drug industry clients, to take that amount of time out of their sheer charitable impulse in order to make democracy work by ensuring compliance with the statutes of Pennsylvania on the part of the Nader Camejo campaign. And so they unleashed their website, bragged, dozens of lawyers and paralegals, and some volunteer law students there for the summer in 2004, in a massive dragnet operation to get us off the ballot, and of course had a very, very convenient judiciary in Philadelphia to help them along. And they succeeded. As if that was not enough, as if it was not enough that they made very atrociously bad law, as if it was not enough that they will be forever tainted at law schools around the country to where they go to recruit young lawyers with this miscarriage of justice. They proceeded to push the envelope and asked the judge to assess costs on the Nader Camejo candidacy, in person, Nader and Camejo. And the judge basically said, how much do you want? And they said, how about $81,000? Done. And we became the first defendants trying to defend ourselves and our rights to remain on the ballot in Pennsylvania, the first defendants in American legal history to be so assessed. Judge Collins once again misread the statute as he was tutored and chided by Justice Saylor. The word petitioner in the statute means the objector. It means Reed Smith. It does not mean Nader Camejo. And the only person who can be assessed costs in the state of Pennsylvania is the unsuccessful objectors, not the candidates. And Judge Collins turned this right around and said it can be done to the candidates. Now, what do you do with judges who regularly misread the statute? What you do with them is you impeach them, because this is a very grave issue. This is not a parking ticket. This is not a forged check. This is a slanderous judge who is either deliberately misreading the law, ignorantly misleading the law, or misleading the law out of sheer negligence and lassitude. All of them grounds for impeachment. Now, it's hard, if you haven't been in our position, to absorb the gravity of what was done and to absorb how this type of expulsion applied to Carl Romanelli 2 years later is going to spread in Pennsylvania and throughout the United States. Reed Smith has, in effect, perfected its role as the law firm King Kong, Ballot Access Buster, with a sign that in effect says, we're open for more business. Because when you can serve a major party in a close election with another major party and expel a minor party candidate, you are going to be rewarded very well in subsequent considerations for business, or at least you're entitled to think that you're going to be rewarded in that manner. I suspect in the year 2008 that there are going to be tactics perfected here in Pennsylvania that will be used in states like Ohio, Florida, and Oregon, Illinois, Indiana, and elsewhere, wherever it is deemed necessary by one of the two major parties. This is not a two-party country. Should not be. Two parties do not own the voters in this country. They shouldn't be allowed to. Instead, what has happened is it has become a two-party country. It is a two-party elected dictatorship when it comes to excluding competition. If the two parties did what they do in the marketplace, they would be indicted for criminal violation of the antitrust laws. But unfortunately, they are in the political marketplace where they write the rules, they pass the Pennsylvania laws, they pass the laws that decide who gets on and who doesn't in 50 states. Canadians must be laughing at us when they see an electoral system where a person who comes in second in the popular vote becomes president, Bush in 2000. Do you know any other democratic society where you come in second and you can become president because of the Electoral College? A system where the debate commission is a private corporation created by the two parties who determine which candidates are allowed to reach tens of millions of Americans by getting on the debate. And of course, they make sure that no one has ever gotten on those debates except Ross Perot in 1992, because Clinton and Bush thought for different reasons it was tactically appropriate for Perot to be on. This is laughingstock material. We should be ashamed of ourselves. And I say this to Reed Smith. You're opening up the greatest confrontation on ballot access of any law firm in American history. So you better get ready. And I say this to the Democratic Party. If you try to do this again and conspire with state Democratic committees and political consultants and phony 527s, you're not going to get a free ride on this cycle. And I say this to the members of Congress. It's time for one federal ballot access statute for all candidates running for federal office, not 50 states. Lacking that, the least the Pennsylvania legislature can do is to pass a bill that replaces the judge by judge, courtroom by courtroom deliberation, counting every vote in terms of whether they met certain ballot access criteria, every signatory on the petition, and put it into a nonpartisan statewide commission so that no party, major or minor, can decide with their partisan judges who's going to get on the ballot and who isn't, and what voters are going to be denied their free choice of candidates. There remains one additional problem, and that is the lack of public indignation based on the lack of awareness. But even if there was awareness, there is an eerie reminder for those of us who know political legal history in our country of the way people were not particularly indignant when African American voters and candidates were driven off the ballot by partisan judges and major party interests in those communities. The kind of decisions that were made in the high state courts in the South in the 30s and 40s, they were deemed legal. But when you read them now, you're horrified by their callousness, their cruelty, their fascistic exclusion of people who wanted to vote and who wanted to run for office just because their color was black. And that's what we're going to see when it comes to ballot access for candidates. I sense that it's going to take a number of further defeats and denial of certiorari by the Supreme Court before they become more and more sensitized to this constitutional right of free speech, which is what running for office is. You speak, you petition, you assemble. It's the most consummate expression of the First Amendment right, that they will judicially defend it with as much vigor as they now destroy it. This will require more competition in our democratic processes. It will require more people to run for office, to challenge these obstructions around the country, and that's the only way they're going to be brought to the surface. It will require more local candidates, state candidates, and national candidates. And in so doing, we will see what we have been missing. Because historically, the great ideas that have animated social justice and driven it to some sort of success in our country have come from third parties. And aren't we glad that ballot access barriers were much lower in the 19th century than they are today, much less obstructive, because that allowed the Liberty Party, the Anti-Slavery Party, the Women's Right to Vote Party, the Labor Party, the Populist Party, the Farmer Party to get on the ballot. And aren't we glad that there were some voters in the 19th century who didn't say, well, we're going to go for the least worst on the issue of slavery between the Whig Party and the Democratic Party, who instead voted for the small party that led the fight, electorally speaking, against slavery? Aren't we glad that there were some voters who didn't try to figure out who the least worst was on the women's right to vote between the Democrats and Republicans and supported the women's right to vote or the women's suffrage party? Well, if we like that, then we should like it in the 21st century as well. Thank you very much. Anybody
What we'd like to do is have all of today's speakers join us up here behind the podium, and we'll do question and answer. And also, as Marek Hay noted before, there are a couple of other important Greens who are with us. Cliff Thornton, who ran for governor of Connecticut in 2006 and faced his own challenge in trying to get into the debates, and also Dr. Janet Eaton from the Green Party of Canada, where they're laughing at us. And can we have a question, please? Yes, sir.
Well, can I ask Mr. Nader the $64,000 question? Do you plan a presidential run in 2008?
Well, as I say about every day now, it's too early for me to decide. One of the reasons is we would have to get thousands of volunteers and pro bono lawyers to get ready for the Democratic Party's quadrennial assault on our right to be on the ballot. I'd never have to say that if I was in Canada, would I? Or Belgium, or Norway, or Germany. So it's too early to say. I'll make up my mind before the end of the year.
Mr. Nader?
Yes.
For all the Go We Go stuff, you've still run again and again as an alternate emperor talking head, looking much like the other patriarchal grand balloons. When I asked 2 years ago why you don't pick a cabinet campaign with you, you said the trouble is who it would leave out. So does that mean that you see cabinet posts like an ambassadorship a reward for service? And why do you still refuse to name 12 or 15 experts in the cabinet areas to embody the progressive platform and offer a photogenic team to excite the 80% of Americans who never vote? Will you name 5 or 6 cabinet heads right now or this evening?
I really admire how prepared your question is. Did you use the word falloon?
That's Kurt Vonnegut's term for the people, the leaders.
Oh, I see. God, anything to enrich the vocabulary of politics, I'm all for that. Really, it's not up to someone who isn't a candidate to do that. I mean, if someone is a candidate, it's an interesting idea, like a shadow cabinet. But I must take issue with your word, since you are a wordsmith, with your word photogenic. Are you representing the Revlon standard of?
Well, look at this picture here.
Yeah.
If you run every 4 years,
Yeah.
it's this guy, it's this possible emperor or this possible
I see.
emperor.
So that's what you mean. You don't mean it in a cosmetic term.
No, not at all.
I
Just
see.
look at you. These are all people that knew. If these were experts in the cabinet areas, you would split up and campaign in, actually problem solve in America every 4 years. Instead of, talking about people's hair or whatever, you'd have experts in the area. And also, by contrast, you would look at the Bush, chickens and the foxes in the chicken coop. It would explode the patriarchal idea.
Yeah.
I'd make myself available for Secretary of State.
With jurisdiction over election laws.
Just as advice for the Green Party.
Let's move on to the next question, please, with all due respect. Any other reporters have questions, please? Becky.
Becky Weber, Greenpeace. Mr. Nader, you talked about what you would have to say to members of Congress, Democratic Party. What do you have to say to members of the Green Party about the case in Pennsylvania?
About what?
About the situation in Pennsylvania.
Oh, no, the Green Party's been struggling. I mean, Carl Romanelli was this, as you know, the Green Party candidate for the U.S. Senate. All the small parties have to get together on this. And they have indicated in prior years that they have gotten together on this, but it's not enough. We need some fair-minded members of the legislature from either major political parties to take a stand. Remember, you're in a state where the governor vetoed the state legislature's attempt to up the number of signatures to 97,000 for a presidential candidate about 10 years ago. Was it Governor Ridge who did that? Yeah. He's a Republican governor, and he vetoed it, and I called him up to congratulate him, and I had urged him to do so earlier, and I said, why did you do it? He said, because it was very unfair. This is very unfair to third parties, so we need allies in the...
I'd just like to add that the Green Party of Pennsylvania has been cooperating with other third parties in ballot access issues.
And don't be afraid to step up to the microphone here. We can catch you a lot clearer. Over here.
Mr. Nader, you said your decision on whether to run in large part will depend on whether you can round up enough volunteers and pro bono lawyers. Are you actively trying to do that right now? Trying to put together an organization?
No, I'm not right now. But obviously I'm getting letters from, just got a letter from a pro bono lawyer in California saying that he's willing to help. So, but no, I'm not actively doing that.
Do you anticipate actively doing that in the months to come?
Yeah, if I move to the next stage, yeah, I will.
Yes, sir.
Mr. Nader, what do you think your role is in helping Green Party candidates like Carl succeed on the local and statewide levels?
Well, I still help and support Green Party candidates. In 2006, as Cliff knows.
Right here.
Yeah, sorry. I supported Cliff Thornton for the governorship. I supported Ralph Ferrucci for the Senate. Actually, Ralph got on the debates, and Cliff was excluded from the debates, the state debates. I went to California and supported Peter Camejo and other jurisdictions as well. So I think the Green Party platform is the best. It's the best platform of any political party. It's a lot broader and deeper than it's given credit for.
Just to add to that, what was produced from the campaign in Connecticut was a video on Current TV, which won the award. In 2 weeks, that video will go national and be aired in 40 million homes. So we are making progress. We just have to continue to keep the pressure on, thanks to Ralph.
And Cliff, that's at currenttv.com, right?
CurrentTV.com.
Okay. Yes, sir.
Paul Van Heeden, brainstroke.com. Considering that Americans can pay their taxes digitally and use a digital signature, is there a front that on your ballot access campaign to allow Americans to sign petitions using a digital signature rather than actually having to sign? Have you thought about this? Is this part of your overall strategy?
Well, as far as I know, it's prohibited by every state law, isn't it?
But they can pay their taxes with
that is
digital
right.
signatures.
Well, that's the next frontier. I mean, why, with the safeguards in place, why should it be, why do we have to stand on a rainy street corner in Houston with, 90-degree temperature, receiving all kinds of catcalls from recovering Democrats, when it can be done electronically? It's really interesting that all of these major party consultants and avant-garde computerists don't really recommend, are not promoting that, because they know they're going to lose control if they do. They're going to lose control of the ballot access obstruction process.
Yes, sir.
Mr. Nader, Ralph Nader. I'm Dan Murphy. I just drove in from Lowell, Massachusetts, so that I could introduce my son Patrick to you. He's running as an independent for the 5th Congressional District.
Age 25.
Age 25, yes. So you read what we sent to you, I don't know.
Yes, of course.
Yeah. So what I'm asking, I have a question for you. What I'm asking is that you spend 2 minutes with me sometime during the evening.
Yeah, sure.
Thank you.
Any other questions from reporters, please? Yes, sir.
You said to Reed Smith, you're opening up the greatest confrontation in ballot access of any law firm in American history, so you better get ready. To the Democrats, you're not going to get a free ride this cycle. What exactly do you mean by that? Specifically the second part, Democrats, you're not going to get a free ride this cycle.
Well, now we're going to be ready for them. And that means we will confront them at every level, the litigation level, media level, investigative level. They better have clean hands.
Can I add something? You might argue the Democrats have blown their playbook because now they've taught the Green Party what tricks there are in the bag, and they're easy to respond to. This can't happen twice. I think that's the important point to consider.
Though I would be quick to add, in Pennsylvania, it did happen twice, and they did modify Instead of ordering us to be in 12 or 13 different courtrooms, instead they forced us to have 9 volunteers every day, 8:30 to 5 p.m., Monday through Friday, for an 8.5-week period. Something that is very difficult for a party with a few $1,000s in the treasury and only 17,000 registered members. So I wouldn't be too sure, but I agree with Mr. Nader that we need to go after them, and we should not, let me repeat, we cannot let these judges off of the hook. We know what we're getting from the politics. What about the courts? This is something that should be chilling to all of you. Look what was done to me, sir. You are putting your son at risk to that kind of destruction as an independent unless we care. It's not a theory. It's not abstract.
Well, didn't you say earlier that you feel like you have to bet your house now to run for office in Pennsylvania?
Well, I can't see how it's not a bill of attainder when the price tag for an independent failed ballot attempt is about $100,000. In my case, it would destroy me if I were forced to pay it. Being a man of modest means and not having the ability to have them take my stuff in order to, because I'm a green, I don't want stuff, I give it away. But they can take my liberty if this is ultimately something that sticks, because failure to obey a court order is punishable by contempt, and contempt carries a penalty of, among other things, imprisonment. I will not be a political prisoner. I will not be a victim. I am a retired officer of the court, and if I can do my duty with honor and distinction at the lowest rung, we won it from the highest courts in this country.
I should probably also add that in 2005, when I was chair of the state party and we were putting a slate together, when I agreed that I would run for governor and I talked to Carl about running for Senate, the first thing I said was, we have to realize that whoever runs in 2006 is going to get sued. And sure enough, that came to pass. And I really credit Carl, and so does the whole state party, for being the person who stood up there and said, bring it on.
Lion.
Lion card. Mr. Nader, is this going to become a Supreme Court case? Ballot access.
Well, we went up 6 times, I think, on 2004, and we were denied cert. But I understand that the last 2 or 3 times there was some modest dissent by Justice Breyer. So I think these are very well-written briefs that we send them, and they've got to read them. Their clerks begin to read them, so it's really an educational process. This is the way the Civil Rights Movement did. The constant up, defeated, up, defeated, up, defeated, and they started to break through. It's going to be a little bit more difficult with this court because Scalia is on record as basically saying this is a 2-party country. I mean, it's a rather bold statement, but I think we may get a cert petition accepted in a few years, I would say. We gave them all kinds of fact situations, and they turned them all down. But we know that there was a lively discussion among the clerks, at least, on this.
Are there any more reporters who have a question? Yes, sir.
Yeah, Mr. Nader, you said that it's kind of like a progressive process to finally get this ballot access to the Supreme Court. How do you think that Mr. Romanelli's case, with the publicity that it received, moves that movement forward?
Well, it was even worse than in my case, where they assessed Mr. Romanelli's with attorney fees and then assessed his attorney. I mean, this is really getting pretty raw. And so the further they push the envelope with their partisan judges, that is these corporate law firms, maybe they'll attract the attention of reporters to dig in and see what's behind all this, who the players are, where who's getting paid, who who covered up. You know, there's a lot of things behind the scenes here that need to be uncovered. There may be some whistleblowers, but I think does that answer your question? Huh?
I've got something
Anybody
to add.
else want to add?
Yes.
Yeah.
In my situation, I was running for Congress in the 14th District, which is Pittsburgh and parts of Allegheny County, which is 200 miles away from Harrisburg, where the counting of the signature process was to take place. So no matter how much confidence I had in my signatures, and I did have confidence in them, I still was subjected to having to spend week after week after week in a courtroom in Harrisburg, 200 miles from my job and my family and my means of making a livelihood. So regardless of how good these signatures are, this is still something that any third-party candidate is subjected to. And then, of course, in my case, my signatures were upheld. But had they not been upheld, I would have been facing the same type of penalty that Mr. Nader and Mr. Romanelli were. And furthermore, in Carl's case, he got a lot of bad press. I got zero press. There was no newspaper in Pittsburgh or anywhere in the state that was willing to mention that my petitions were being challenged. So I was helpless, unable to get any help from outside, and we had to rely only on our own means, which fortunately were enough, but still, it's something that candidates should not have to go through.
Just as an aside, see how the system is rigged? Look how the system is rigged. No one would say that Mexico and Brazil had the level of democratic processes that we have in our country, with all our imperfections. But in Mexico and Brazil, you could elect, you could almost elect an Obrador, or you can actually elect a Lula, and I think Obrador won, but you could never do that in the United States. The system is too rigged. You could never elect a really populist candidate with a record of accomplishment. And we're supposed to be more democratic, small d, than the Mexican oligarchic system or the Brazilian plutocratic system. But they had enough elbow room and enough electoral flexibility so the voters could actually elect someone like Lula and Obrador. So these comparisons are very important with Western democracies, third world countries, just to show us how serious the problem is here. I mean, what other country can people run for office and be praised for all of their record of achievement and get very few votes because they don't fit in a corrupt, rigged electoral college, two-party, winner-take-all system? That excludes them from the debates. I mean, let's get serious here. We're losing our democracy, I used to say, on the installment plan. I have to find another metaphor, especially with what's going on in Washington.
Take one more question. Well, we'll take two more questions. Go ahead.
Mr. Nader, you mentioned in talking about the Pennsylvania petition challenges, how a voter who signs a petition and they've moved and not updated the voter registration should still have the right to sign that petition. But doesn't that invite voter fraud? If somebody has, say, moved and in 20 years hasn't updated the voter registration information and may not even live in the same precinct or the same county anymore, why should they still have full voting rights? What if they tried to vote? I mean, that would be voter fraud.
No, in Pennsylvania, there's a number of people who continue, for example, to be registered at their parents' home. So they might be off and married, but they go back to that original district to vote. As long as they have a residency there, that's perfectly legal, because the Pennsylvania voter law doesn't require that you be domiciled where you are registered, just that it be consistent. So someone signing their name for 20 years at their current address with their spouse, you get them on a street corner at the mall, they scribble their current address instead of remembering, oh, I'm registered at Mama's house. The question is, if you are going to scrutinize each voter's signature to that standard, then what about the standard we hold the challengers to? We get challenged without any specificity as to what's wrong with these signatures. In my case, it was too overwhelming for not only the Democrats to prepare a challenge, but also for the Department of State to competently handle that challenge. Where's the demand for them? Just hold the system to the same level that you are trying to hold a voter, and everything will be fine. But when we expect perfection on the part of you, and then these major systems could make any mistake in the world and still get to roll over you, what's wrong with that? Is that the spirit of the American horse? And why are my countrymen and women just laying down and taking it? We must fight back, and we must expose this.
First of all, why do we have these registration requirements anyway? North Dakota, same-day voter registration. You show up to vote, you register. One. Canada, it's done in the census, isn't it? It's part of the census. It's over after you're counted in the census. And here we are figuring out, parsing this and that and so forth.
And in my case, a judge never looked at the signatures. It was all the volunteers. And then they tried to take me to contempt court to hold me in contempt for not having enough volunteers. So we were able to get the lawyer to pay for a temp service to help us. Well, then the Democrats are able to put their own person as a plant in the temp service, and they go to court saying, here's a Green Party volunteer that stipulated to this, and the court knows what's going on. And they sit there. And on January 9th, as we were going through that kangaroo court on the appeal, the three other judges from the same body, the Commonwealth Court of Pennsylvania, decided a case in which they said attorney's fees cannot be assessed in these areas unless fraud or forgery are demonstrated, not alleged. And ironically, it was a case that began in my hometown for a local activist who was fined $11,000 by a Democratic judge for trying to organize regarding a firehouse in the neighborhood. It was taking the Nader case and applying it to little old Luzerne County. Well, the Commonwealth Court said this is out of line, judge is out of line. They overthrew it the same day that I'm sitting with Judge Kelly in this kangaroo court with no one paying any attention to the good faith and the quality of our filing. Make no mistakes, the Green Party filing was not wrought with forgery, but it was wrought with integrity. It was an unbreakable challenge, and that's why it took them 9 weeks, and in the long run, they had to cheat to pull it off, and I feel violently deprived of my right to articulate these important issues that have made our country a stinking waste dump that we carry in our hearts every day. I'm sick and tired of the good, nonviolent nature of us resulting in us always being kicked aside. I too am nonviolent, but I am not passive, and we must fight back or we're going nowhere.
You also have to realize that the discussion of whether a voter has moved or not is just one of the shams that the courts are throwing up against us now. I handled a case in 2005 where a candidate was thrown off the ballot in Dauphin County for such exciting reasons as not having changed his driver's license. And for that matter, talking about people who move, how about the people who don't move? I don't know about any of you, but my parents lived in the same house for 40-some years. Now, in case you haven't noticed, people's handwriting changes a little when they get older. And yet, someone who lives at the same address for 40-some years isn't going to keep registering to vote. I have been working on cases where I have seen both the Democratic Party assailants and judges saying, well, look, this handwriting is not the same as the handwriting on file for a person who is now 70 years old and registered to vote when they were first able.
In Ohio, in 2004, we had a champion signature gatherer in Toledo, and all of her signatures, well over 1,200, were disqualified on the grounds that her handwriting at age 52 was different from her handwriting when she registered to vote at age 21. This is what's going on. By the way, same-day voter registration in Minnesota helped elect Ventura. We're not just talking theory here.
Yes,
And he only had to get it
I
in
spent
date.
4 weeks in Harrisburg looking at people's signatures and verifying them. And I can tell you categorically from my experience that when you're talking about the address on file in the voter record system and the address on the petition being different, we're not talking about people moving away for 20 years and being far away. By and large, what we're talking about are, say, students who registered to vote when they lived in the dorms, and then a couple semesters later, they move off campus, but they still vote at the same place. It's still in the same precinct. Also, what was not uncommon was when the Pennsylvania voter registration offices made their database, there were there were typographical errors. So instead of writing 81 Washington Street, they wrote 18 Washington Street. Yet these were still disqualified, even where it was clearly a typographical error on the part of the state. And this is not uncommon at all.
Let's take one more question, but before we do, let me remind everyone that in a few minutes the rally will begin over at Sovereign Performing Arts Center at 6th Street and Washington. That's 1 block away. Look for the marquee that says Green Party. And yes.
Thank you for the token. I'd like to know what Mr. Nader or any of you other would specifically recommend to people, common people, to do to thwart this in states that have yet to have been affected.
Someone once said, the only thing that guarantees our freedom is personal responsibility. And we lost that somewhere between Vietnam and presidential fellatio. The only thing that guarantees ballot access and getting us into debates is responsibility. We have to be responsible, and the only way you're going to do that is continuously put the pressure on the Dems and the Repubs. If we don't keep running candidates for office, do we or do we not deserve what ensues?
I can answer the question based on what happened in Illinois last year. It was a strange circumstance in that the media in Illinois happened to loathe the incumbent governor, who managed to waste $800,000 of taxpayer dollars. They were more than willing to burn him, and the general public started to wake up. So when our candidate for governor of Illinois got on the ballot in Illinois, that was Rich Whitney, he got 360,000 votes, and he got 10% of the vote, and we have an established party in Illinois because of that. So the voters have proven that when there is cooperation and not obstruction from the media, that they will follow through and they will do the right thing. A lot of it is on pressuring the media.
Obviously, a lot of the changes come from the legislature, so there has to be pressure on the legislature. And a lot of changes is to generate more judicial decisions so that the type of proper interpretation of Pennsylvania law, as Justice Saylor concluded, will become the norm. In effect, it would overturn the kind of misinterpretation by Judge Collins. That would take care of tens of thousands of signatures that are now disqualified. The address, the registration address, whether you are registered and can sign a petition, etc. That's already in the statute. You just need judicial affirmation.